Prior security checks. Why and when is a prior security check carried out? Where the Commissioner considers that the processing or transfer of data by a controller or a processor may pose a particular risk to the rights of individuals, the Commissioner may inspect and assess the security measures taken under Section 31 of the DPA prior to the beginning of the processing or transfer. The Commissioner may at any reasonable time during working hours carry out further inspection and assessment of the security measures imposed on a controller or a processor in accordance with Section 31. Compliance audit. Why is a compliance audit conducted? The Commissioner may carry out periodical audits of the systems of controllers or processors to ensure compliance with the DPA. The purpose of such audits is to identify problems of non-conformity and suggest recommendations. Obtain a complete picture as far as possible of a structure of personal information flows within an organization so that the appropriate compliance procedures can be put in place to ensure that the organization deals with personal data in accordance with data protection law, the general law, and best practices. Offences and penalties. Unlawful disclosure of personal data. A controller who, without lawful excuse, discloses personal data in any manner that is incompatible with the purpose for which such data has been collected shall commit an offence. Any processor who, without lawful excuse, discloses personal data processed by him without the prior authority of the controller on whose behalf the data are being or have been processed shall commit an offence. Case scenario. In the case of Y versus Turkey, the applicant was HIV positive. As he was unconscious during his arrival at the hospital, the ambulance crew informed the hospital staff that he was HIV positive. The applicant argued before the European Court of Human Rights that the disclosure of this information had violated his right to respect for private life. However, given the need to protect the safety of the hospital staff, sharing this information was not regarded as a breach of his privacy rights. There are various offences and criminal penalties under this Act, which in general, if committed, are sanctioned by a court of law. Where no specific penalty is provided, any person who does not comply or contravenes this Act shall, on conviction, be liable to a fine not exceeding 200,000 rupees and to imprisonment for a term not exceeding 5 years. Section 6. Investigation of complaints. Any person who fails to attend a hearing or to produce a document or other material when required to do so to the Data Protection Office is liable to a fine not exceeding 50,000 rupees and to imprisonment for a term not exceeding 2 years. Section 7. The Data Protection Commissioner has the power to require information, and any person who fails or refuses to comply with this requirement as specified in a notice, or who furnishes to the Commissioner any information which he knows to be false or misleading in a material particular, is liable to a fine not exceeding 50,000 rupees and to imprisonment for a term not exceeding 2 years. Section 15. Any controller or processor who knowingly supplies any information during registration which is false or misleading in a material particular is liable to a fine not exceeding 100,000 rupees and to imprisonment for a term not exceeding 5 years. Section 17. Any controller or processor who fails to notify a change in particulars is liable to a fine not exceeding 50,000 rupees. Section 28. Lawful processing. Any person who processes personal data unlawfully is liable to a fine not exceeding 100,000 rupees and to imprisonment for a term not exceeding 5 years. Exceptions and restrictions under the DPA. Sections 3, subsection 4 and 44 depict the types of processing of personal data which are exempted from the DPA. For instance, the processing of personal data by an individual in the course of a purely personal or household activity is exempted from the DPA. There are other further exemptions available where processing of personal data constitutes a necessary and proportionate measure in a democratic society for the protection of national security, defense, or public security, the prevention, investigation, detection, or prosecution of an offence, including the execution of a penalty, an objective of general public interest, including an economic or financial interest of the state, the protection of judicial independence and judicial proceedings, the protection of a data subject or the rights and freedoms of others. The processing of personal data for the purpose of historical, statistical, or scientific research is also exempted, provided that the security and organizational measures are implemented to protect the rights and freedoms of data subjects involved. The controller or processor has a duty to secure the data to prevent its unlawful disclosure. For example, appropriate technology such as pseudonymization or encryption can be used to secure the data. Certification to enhance transparency and compliance with the Data Protection Act. Certification has been introduced to help controllers or processors to demonstrate accountability and compliance with the Act, build confidence and trust in the organization with all stakeholders as well as with the wider public, allow data subjects to quickly assess the level of data protection of relevant products and services, give legal certainty for cross-border data transfers. Certification will be issued by the Data Protection Office, who is the certification body. It is voluntary and free. It is valid for 3 years and is subject to renewal. Controllers or processors may apply for renewal of the certification before the date of its expiry. It is subject to withdrawal where the conditions for issuing the certification are no longer met. Does the absence of certification or failure in receiving certification have any negative effect on the controllers or processors? Being unsuccessful in receiving a certification from the DPO or generally withdrawing from the certification application process is not sanctioned as such by the DPO. However, the absence of certification may lead to compliance issues for controllers or processors as it cannot alter the responsibility for compliance. How is the certification process carried out? Controllers or processors will need to apply for certification by filling in the application form. If registration and renewal payment is up to date, the Data Protection Office will conduct an audit on an arranged date at the controller's or processor's premises. The Data Protection Office will write a report about its findings and will decide if certification can be granted. Certification with seal will be remitted to controllers or processors. Corrective actions may be recommended to controllers or processors to be implemented in X number of days. On the basis of which criteria is certification issued? Implementation of appropriate technical and organizational measures, including internal data protection policies such as staff training, internal audits of processing activities, and reviews of internal HR policies. Maintenance of relevant documentation on processing activities. Implementation of measures that meet the principles of data protection. Example, data minimization, pseudonymization, improvement of security features on an ongoing basis. Appointment of a data protection officer. Use of data protection impact assessments where appropriate. What are the benefits of certification? Certifications carry tangible benefits for controllers and processors. They create trust, greater transparency, effective privacy protection. If implemented effectively, certifications may convey a number of key benefits to controllers and processors, as they demonstrate accountability and compliance, and they enable cross-border data transfers more smoothly. If you have any queries regarding data protection, contact the Data Protection Office for advice.